May I please? Or for listing Millard, 2 matters Millard, may I pray after vacation Millard, 25th or 26th?
May I please, Your Lordship? With the consent of other set, I beg to mention item number 14, Lordship. In this case, we are appealing for the sole respondent, Lordship. And the respondent company has newly engaged Learned University PK Tiwari, Lordship. Lordship may fix the matter first week of May, Lordship.
Mr. K. Kalita, Learned Counsel for the respondent submits that senior counsel to argue the matter on behalf of the respondent has been recently engaged, and therefore this matter be taken up again after 3 weeks. Full stop. This matter be listed for hearing again after 3 weeks. The prayer is not opposed by the petitioner's counsel. As such, hearing of this matter stands adjourned for 3 weeks.
May I please, Lordship? I may be allowed to move an urgent motion tomorrow, Lordship, pertaining to selection and appointment of Gampura. I will be praying for a similar order. Your Lordship has already disposed of.
Mic is not working. That mic is not working. Yes, next.
May I please, Your Lordship? Lordship, I am praying for listing one fresh motion matter, Lordship. I have filed on 11th, Lordship. Immediately after Lordship with vacation, Lordship.
Next
On
week.
26th of
Next
Lordship.
week.
May I please, Your Lordship, I beg to mention WPC number 2109 of 2019 for listing, Lordship.
Yes.
Any convenience?
All matters will be listed, but you are not telling the urgency why you want the matters to be listed.
Lordship, it's a promotional matter, Lordship. Any convenient date as per, because it was posted on 2022, Lordship.
2nd week of May, you put a date.
May,
Yes.
Lordship.
Yeah, please, Your Lordship. Lordship, I beg for listing of a matter. It's a matter related to promotion of a petitioner. So it was last listed in the month of December, Lordship. So there is some adjustment. So next week.
Second week of May, put a date.
Much please, Your Lord.
Lordship, I beg to mention one matter, my lord. It's a matter relates to my lord, area salary, my lord. And the petitioner is highly, my lord, he is seriously ill, my lord. He has some multiple disease, my lord. He needs some treatment, my lord. Maybe letter will be listed on next week, my lord.
Lordship, I beg to mention a case for listing tomorrow.
What case? What listing?
Pertaining the matter is for appointment of a Gaon Pradhan in Nagaon, at Nagaon.
Why tomorrow?
Because my senior told us we need to.
You tell your senior that court has asked why tomorrow. Go and ask and then come back. Your senior cannot decide. The decision has to be from the court, is it not? So you have to answer the question. Why you want it tomorrow? Why not next week? You ask your senior next time when he tells you. Right.
May it please, Your Lordship. Lordship, with the consent of the petitioner, I beg to mention item number 6, Lordship. Yesterday, I have given a slip, Lordship, to the court master. Item 6, Lordship.
On the prayer of Learned Standing Council, Health Department, Assam, made with the consent of the other side, admission hearing of these matters stands adjourned for 2 weeks.
Highly obliged, Lordship.
Or move on item 1.
May I please, Your Lordship. My Lordship will find. Page 21, page 17 and 21. Admitted fact is that allopathic doctors and Ayurvedic doctors who are working in the health department under the government of Assam are being given the same scale of pay. However, for allopathic doctors working under NHM, Assam on contractual basis, they are being paid fixed salary of 50,000 per month, while Ayurvedic doctors are being paid fixed salary of 30,500. Now the direction Your Lordship will find. 21 was the para 16. In view of the reason stated above, the respondents are directed to pay and release the salary of the petitioner at par with the allopathic medical doctors at NHM Assam, with effect from the date of filing of this rate petition. Now they have made it conditional, my lord. Your Lordship will find. Annexure 2, in the name of compliance. After that table, my lord, Your Lordship will find the existing medical officer Ayur, doctor under NHM Assam are hereby eligible to draw the revised initial remuneration for corresponding period as so and so from 18 to only from what, in case doing lesser remuneration, these are the conditions they have imposed, my lord. Whereas since we have filed this case because the 2012-13, we have been paid equal pay, we have been paid 30,500. Then against next year of that is 2013-14, they have been paid 40,000 per month with annual increments. And we have been remain at 30,500 with annual increments. Now, if we count that one, my lord, now we are getting more than 50,000 at present there, my lord. So this order does not apply to us. It is not equal with the medical, my lord. So therefore, there is a direct contempt, my lord.
You have to file a writ petition now. They
Now,
passed an order.
petition we have filed. Petition we have filed.
Where is the writ petition? Challenging this notice?
Yes, challenging this one.
What is the number?
Oh, number, my lord. Sorry, my lord, I don't have name to the number, but we have filed petition.
Bring that number. We'll post it along with that.
Okay, sir. Yes,
But your contempt case is not maintainable. We'll pass that order after going through the writ petition.
yes, my lord. This matter will listen along with the petition. Then, my
Give
lord.
the number.
Number I don't have to them.
On prayer of Mr. So-and-so learned counsel for the petitioner, this matter stands adjourned for a week.
My lord, that matter of Industrial Cooperative Bank. And on the last occasion, your lordship wanted to know about the decisions as to how a person will be treated as a workman. Now I have,
No, we have to go through the whole thing again.
my lord,
So
My lord.
there's a need to refresh.
My lord.
Well, here the respond number 5. While he was working as a branch manager in the Guwahati branch of the Industrial Cooperative Bank, during the period of 1/11/2008 to 30/09/2010, my lord, there were some overdraft account, my lord, where he has allowed excess dwell beyond the sanction limits, and for which the bank has suffered loss. And a departmental proceeding was initiated. He was so forth. He has submitted his reply, and subsequently he has been given all opportunity in the departmental proceeding, and a detailed inquiry report was submitted. And subsequent after the inquiry report, he was also so caused on the proposed punishment. He submitted his reply and he was removed from service. Now the respond number 5, who was a branch manager at the time when for the period where he was being charged, and at the time of the removal, he was a chief manager. He filed an application first before the labor commissioner for initiating a conciliation proceeding. A notice was issued to the bank. Bank contended that he is not a workman under section 2S, as he was holding an administrative and managerial post, and therefore no conciliation proceeding was initiated. He filed an application under section 2A, challenging the removal order. Now the notice was issued to the bank. Bank initially appeared and filed an application questioning the maintainability of the petition. That because section 2A clearly provides that a workman can assail the order of dismissal. For that, he has to come under the ambit of workman. That application was rejected on the ground that this is a mixed question which has to be decided only after adducing of evidence. Thereafter, the bank did not appear and the matter proceeded ex parte. Now, the award, my lord, which has been passed by the Labour Court has set aside the removal order. The Labour Court, while setting aside the removal order, has exercised section 11A of the Industrial Dispute Act. And section 11A of the Industrial Dispute Act, my lord, provides that the Labour Court has to adjudicate on the merit of the proceeding, and on being satisfied that the removal order is not justified, can set aside the order. But if your lordship will find the award at page 240.
214.
214.
Yes.
Correct.
May I read the award? The proceeding has been initiated on the strength of a petition number 17/19 under section 2A of the Industrial Dispute Act by the workman with a prayer for full salary during his period of suspension, reinstatement with back salary and other benefit. It has been averred in the petition that the workman on 1/1/1987 joined the Industrial Cooperative Bank Limited, but he was dismissed from service on 8/2/2018. Despite discharging his duties honestly, sincerely, without any blemish, for which he was promoted up to Chief Manager, HR Administration. The Managing Director of the bank's management is the chief and sole responsible person for all affairs of the bank. That on 29/7/2015, the management number 2, as an inquiry officer, started an inquiry against the petitioner workman for overdrawing in accounts despite knowledge of the higher authority, and the inquiry officer, while disposing the inquiry, opined for framing charges through the disciplinary authority. The workman, being an employee of the Workers Association of the bank, was elected as a general secretary, for which the management got unhappy and immediately issued suspension order by dated so and so 24/8/2016 without any reason. Thereafter, the management by later dated so and so intimated the workman that the earlier inquiry officer did not discharge, for which the opposite party number 3 has been appointed as a fresh inquiry officer. Being aggrieved, the workman prayed direction from the Honorable Court, and on being satisfied, the Honorable Court was pleased enough to pass an order, Exhibit H, for revocation of the suspension order against the workman, and also directed to continue with the disciplinary proceeding. But the opposite party number 1, without execution of the order of the Honorable High Court, the rules of staff service, and during the pendency of the reference case number 12/17 of the Labour Code, arbitrarily and illegal manner dismissed the workman by order dated 8/2/18. That the workman also approached the Labour Commissioner and the authority twice to issue to the management for comment on the application of the workman, but nothing was done, hence the instant proceeding. The management, on receipt of the notice, initially filed the petition number section 57A challenging the maintainability of the case without filing written statement. However, the said petition along with the written objection were heard and disposed, rejecting the petition of the challenged opposite parties and also giving chance for submitting written statement. But the management failed to submit the written statement, even did not take any step in case for which the proceeding has been proceeded ex parte against the opposite parties. The workman has submitted the evidence on affidavit testifying the entire contention narrated in the plain complaint and exhibited the aforesaid document. The evidence shows that the management removed dismissed workman, and there was disciplinary proceeding against the workman as admitted by the workman himself. But nothing was produced about the result of the said disciplinary proceeding, and not even the charges of the said disciplinary proceeding. The management did not take part in the proceeding as stated herein above. Therefore, the veracity and authenticity of the contents of the evidence of the workman has been remained unrebutted and unshaken in the case in our hand. Therefore, the workman is deserved to be reinstated with full salary during his period of suspension and back salary and other admissible benefits. Now, if your lordship will find the evidence on affidavit, though it is an ex parte proceeding, that will not allow the Labour Court to set aside the order of removal whimsically without coming to a finding that the removal order was bad. Now, the evidence on affidavit, the Labour Court has herein observed that the result of the disciplinary proceeding is not known. The removal is the outcome of the department disciplinary proceeding. And in the evidence on affidavit which was filed by the workman, they have exhibited the charge sheet, the show cause notice, everything. Everything was before the Labour Court to decide on the merit of the disciplinary proceeding. Now, may I just take your lordship to section 11A for a moment?
Yes.
Section 11A confers the power upon the Labour Court to adjudicate on a case of discharge and dismissal of a workman. May I read? When an industrial dispute relating to the discharge or dismissal of a workman has been referred to a Labour Court tribunal or national tribunal for adjudication, and in the course of adjudication proceeding, the Labour Court tribunal or national tribunal, as the case may be, satisfied that the order of discharge or dismissal was not justified, it may by its award set aside the order of dismissal or discharge
and direct reinstatement of the workman on such terms and condition, if any, as it thinks fit, or give such other relief to the workman, including the award for any lesser punishment in lieu of discharge or dismissal as the circumstances of the case may require. Provided that in any proceeding under this section, the labor court or tribunal or national tribunal, as the case may be, shall rely on the materials on record and shall not take any fresh evidence in relation to the matter. So, my lord, the provision, my lord, the word satisfied makes it clear, my lord, that there has to be a judicial adjudication on the merit of the department proceeding. And if from the award, it is very clear, my lord, the labor court did not arrive at any satisfaction that the removal order is just unjustified or the departmental proceeding is deholds the rules. Now, the allegation which has been leveled.
So you said the bank has filed an application
My lord.
taking a plea of demurrer that the respondent is not a workman.
Yes.
Where is that application?
My lord, that application we have not annexed, my lord.
Hmm.
But
Is it there in the LCR?
My lord? Yes, the records are there.
And then how that application has been decided?
That application was rejected on the ground that this is a mixed question.
Where is
Whether-
that order? Where is that order?
Well, that the reflection of that order is there in the award itself, my lord.
Where is it?
The order. Is 216. Third paragraph, my lord.
No, it says it was heard and disposed of.
Yes, my lord, it
Where
has,
is the
it was
order of
heard and disposed, rejecting the petition, challenging the opposite party and also giving chance for filing written statement.
Which is that order by which it was rejected?
My lord, that order is not, it is there.
It is there in the record 22/4/2019.
22.
Orders.
Have you challenged that order?
My lord, no.
So therefore, whether he is a workman or not, that aspect of the matter cannot be reopened.
My lord, the question of maintainability, we have questioned in this petition also because the award, the labor
No,
court
you see,
having.
what I'm asking a simple
Yes.
question, that could be your submission,
My lord,
but the facts are facts.
my lord,
You have raised issue of maintainability
my lord.
that was gone into by the labor court and dismissed. Your plea was rejected and you have not preferred any petition against that.
Labor court did not reject the application
Hmm,
saying that the petition is maintainable.
hmm.
It says that at this preliminary stage, as it is a mixed question, it cannot be decided.
Where is the order? Let us see.
Evidence in line. Judgment kita code itu pointer itu judgment kita. Nah, notun kita lagi kita. Kami kita salam. Asal kita berhasil. Itu আছে।
So this order,
Malam,
you have not challenged.
malam, disorder.
Then the court will have to hold that you have accepted that he is a workman.
Malam,
That is how law operates, Mr.
Malam. But the finding of the labor code in that order is
Is
not,
good because you have accepted it.
is not holding him as a workman.
No, your plea that he is a workman has been turned down and you have accepted it. What is the ground on which it is turned down is another matter.
Malam.
But you have accepted it. So now you cannot argue that he is not a workman.
Malam, the challenge which has been done in this repetition is on two grounds. Malam. One, the labor code while exercising.
Come to
section-
that, but do you agree that he is a workman which you have accepted?
He is not a workman. Malam, in fact, Malam,
Then why have you not challenged that order by
Malam,
means of
the
which?
entire proceeding went ex parte, Malam, only after the award which has been passed.
No, you mean to say in the writ petition, you could not challenge this order?
Malam, in the writ petition, we have challenged the award, Malam. The award and the.
All right, you proceed, please.
Malam.
I'll pass. But I'll mention that you have not challenged this order and accepted that he is a workman.
Malam,
Whatever else is mentioned, I don't know.
Malam,
That much I'll mention.
Malam.
That management is accepted that he is a workman.
But the contention of the writ petition in para 4,
Hmm.
that we have made a categorical statement that he was all along working in a managerial post that brings him outside the purview of section 2S.
Hmm.
And the judgment, my lord, passed by the labor code, which is not maintainable, my lord, becomes a non-existent law. My lord, the labor code did not have the jurisdiction under section 2A to try the proceeding, my lord, because section 2A makes it very clear it can be done only if an industrial dispute of an individual is deemed only when it is raised by an workman. And the section, may I just draw your lordship attention to section 2 as the definition of workman. And it is an admitted fact, my lord, that
Mr.
he,
Porshik, that part will freeze it for all times to come because you have not challenged it.
that order.
You can argue, but the finding of the court, I am telling you,
Ma'am.
that you have accepted the order of the labor court on that point. This issue, whether it is allowed, dismissed, remanded, you cannot ask
Well,
this issue.
in my humble submission, my lord, the order of the labor court dismissing the application of maintainability
Hmm.
on as saying it is a mixed question,
Hmm.
my lord, keeps it open for challenge in the subsequent column.
No,
But
the
as-
order says it is dismissed in limine.
my lord,
It is dismissed in limine. Your application was dismissed in limine.
my lord, the observation for which
So
my
there
lord-
is no need to challenge it. That's what your
no,
argument
no,
is.
it was. My lord,
Is this an argument you believe or you are just making it for the sake of it?
in my humble submission, my lord, the question of maintainability is always open. My lord, because it goes to the root of this jurisdiction. My lord, section 2S, my lord, defines the workman, my lord, may I just read?
2F,
2S.
yes. Yes,
Workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical operation, clerical or supervisory work for the hire or reward, whether the terms of employment be expressed or implied. And for that purpose of any proceeding under this act in relation to an industrial dispute includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute or which dismissal, discharge, or retrenchment has led to that dispute, but does not include any person. Roman 3 and 4 will be applicable, who is employed mainly in a managerial or administrative capacity, who being employed in a supervisory capacity draws wages exceeding 10,000 rupees per mason, and exercises either by the nature of the duties attached to the office or by reason of powers vested in him, functions mainly of a managerial nature. And this is admitted that he was a branch manager. When he was removed, he became the chief manager, HR and admin, which is just next post to the managing director. In the evidence on affidavit also, Bharat, he has accepted his capacity.
where is his evidence in affidavit?
Page 206, Madam. Para 1, that I joined in my service on 1/1/1987 as office assistant in the Industrial Cooperative Bank herein after the bank. And the bank management has promoted me in the number of times to higher posts, such as junior officer Roman 2, junior officer 1, assistant branch manager, manager development, and chief manager HR and administration. Para 2, that he disputes that he was never been given an administrative work. I was entrusted with clerical works of the bank. No financial, administrative, and supervisory powers was allowed to me by the bank management and categorized me as a staff under the provisions of staff service rules SSR of the bank. As per staff service rules, I am liable in all respect of my works before the secretary, director, managing director, and the chairman of the bank. I was entirely under the direction, control, and supervision of my higher officers and the management of the bank. Now, my lord, he refers to the staff regulation, my lord. The staff regulation, can I just move this regulation? Yes.
Yes,
Staff regulation, chapter 2, my lord, regulation 7 is the categorization of the employees. Lordship will find Roman 2. Roman 1 is a senior management grade, which includes secretary and the chief manager, accounts, HR and administration, credit development. And
Roman 2 is the middle management grade, which is earlier designated as senior officer grade 2, branch manager, additional or assistant branch manager. So being the branch manager, my lord, he was the middle management grade, which is his second post of the chief manager, and he was the head of the entire branch. He had been
So supposing if supposing the court somehow holds that he is not a workman,
my lord.
what is his remedy?
My lord, he can always challenge. Well, if he challenges the removal order on the ground that it is divorce the rule or it's violation of the principles of natural justice, then he can always come under Article 226.
Mr. Chakraborty, there is a possibility that this kind of a finding would emerge. So we will have to satisfy the court. Merely by saying yes or no will not.
No, man, I'll definitely address your lordship on this point.
So please take a note of this. This is a troubling question. Chief manager who's next to the managing director is a workman. You have to very well satisfy the court that it is. It appears these things have been perfunctorily brushed aside by the labor court. There is no real decision by application of mind. These are avoiding the question. Mixed question of law, fact, we'll see later, etc. These orders do not comment for recommendation,
Man,
acceptance.
once it's finished, I'll address your lordship on this. On every point is urgent.
Page 25 of the staff regulation, my lord.
Hmm.
The branch manager is an apprising authority of the assistant grade employee, junior officer grade, and senior officer grade, and the subordinate grades. So, my lord, this clearly indicates that he has an administrative, he works in an administrative capacity and a supervisory capacity. Now, section 2A,
This is staff service rule.
staff service rule. This is the rule, my lord, which governs the conditions of all employees of the bank.
Yes.
Now, may I draw your lordship attention to section 2A, under which the proceeding was initiated.
Yes, 2A of the industrial. dispute.
Industrial dispute.
Yes.
Dismissal, etc., of an individual workman to be deemed to be an industrial dispute, where an employer discharges, dismisses, retrenches, or otherwise terminates the service of an individual workman. Any dispute or difference between the workman and his employer connected with or arising out of such discharge, dismissal, retrenchment, or termination shall be deemed to be an industrial dispute, notwithstanding that no other workman or any other union or workman is a party to the dispute. Notwithstanding anything contained in section 10, any such workman as is specified in subsection 1 may make an application directly to the labor court or tribunal for adjudication of the dispute referred to herein after the expiry of 45 days from the date he has made an application to the conciliation officer of the appropriate government for conciliation of the dispute. And in respect of such application, the labor court and labor or tribunal shall have the power and jurisdiction to adjudicate upon the dispute as if it were a dispute referred to it by the appropriate government in accordance with the provisions of this act, and all provisions of the act shall apply in relation to such adjudication as they apply in relation to an industrial dispute referred to it by the appropriate application. So, my lord, this application can be filed only by a workman.
All right.
Well, and the second round of challenge, which I argued, my lord, that the labor code also failed to exercise
the powers and the jurisdiction which has been conferred under section 11A. My lord, the section 11A has been dealt by the Honorable Supreme Court. My lord, I have placed some certain judgments. A compilation was given last time. Your lordship takes up the judgment. Please.
এখানে একটা bundle করে দেবো। আমি কথা বলছি, click করছি। Yes,
But first page 1, my lord. USA Breco Mazdoor Sangh versus Management of Messrs. USA Breco Limited.
Hmm.
Here, my lord, the applicability of section 11A was the issue. Page 4, para 8, my lord. Sorry, my lord. Page 14, page 5, my lord, para 14.
yes,
Validity or legality of a domestic inquiry, as also the question as to whether the principles of natural justice had been complied or could not be determined by way of a preliminary issue, what would be the extent of jurisdiction of the labor court in this behalf, had come up for consideration before this court in a large number of decisions. The view taken by this court was that if the conclusion arrived at by the inquiry officer on the materials placed before it was a possible view, the labor court would have no jurisdiction to substitute its own judgment, although it could itself has arrived at a decision, different conclusion on the same material. In Delhi Law General Mills Supra, this court entirely relied upon the aforementioned decision amongst others to opine that the propriety of the domestic inquiry held by the management should be gone into as a preliminary issue, and in the event that the same is decided against it, a request could be made to the tribunal to permit it to adduce press evidence before it. Keeping in view the diverse opinion rendered by the High Courts, which had been noticed by this court in Delhi Court and General Mills Supra, the Parliament inserted Section 11A in the Act, which came into force with effect from 15/12/1971. The statement and objection reasons for inserting Section 11A of the Act, it was stated in Indian Iron and Steel Company Limited versus Workman, the Supreme Court, while considering the tribunal's power to interfere with the management decisions to dismiss, discharge, or terminate the service of a workman, has observed that in case of dismissal on misconduct, the tribunal does not act as a court of appeal and substitute its own judgment. For that, the management and the tribunal will interfere only when there is a want of good faith, victimization, unfair labor practice on the part of the management. The International Labour Organization, in its recommendation concerning termination of employment at the initiative to the employer, adopted in 1963, has recommended that a worker aggrieved by the termination of his employment should be entitled to appeal against the termination, among other, to a neutral body such as arbitrator, a court, or an arbitration committee, or a similar body, and that neutral body concerned should be empowered to examine the reasons given in the termination of the employment and other circumstances relating to the case and to render a decision on the justification of the termination. The International Labour Organization has further recommended that the neutral body should be empowered if it finds that the termination of the employment was unjustified to the order that the worker concerned, unless restrained with unpaid wages, should be paid adequate compensation for the afforded some other relief. In accordance with this recommendation, it is considered that the tribunal's power in an adjudication proceeding relating to discharge and dismissal of a workman should not be limited, and the tribunal should have the power, in case wherever necessary, to set aside an order of discharge and dismissal and direct reinstatement of the workman on such terms and conditions, if any, as it thinks fit, or give such other relief as to the workman, including the award of any lesser punishment in lieu of discharge or dismissal, as the circumstances of the case may require. For this purpose, a new Section 11A is proposed to be inserted in the Industrial Dispute Act. We may, however, notice that new Section 11A was not noticed by this court in Delhi Court and General Mills Supra, although the same was inserted on 15/12/1971. Interpretation of Section 11A came up for consideration before this court in Firestone Tire and Rubber Company. It was opined that Section 11A of the Act had brought about a complete change in this behalf. The court, despite insertion of Section 11A, not only conferred jurisdiction on the tribunal to
alter the quantum of punishment imposed upon a workman, but also held that it can enter into the merit of the matter so far as determination of the proof of misconduct or otherwise on the part of the workman is concerned. Two extreme views, namely, the entire law has been rewritten, and despite the insertion of section 11 in the management neither could raise legality or validity of the domestic inquiry as a preliminary issue or request the tribunal to allow adduce evidence before it even no inquiry has been held, or as whether such right can still be exercised by the management came up for consideration in Firestone Tire Rubber Company Supra. One of the questions posed by Padilangam Justice was as to whether section 11A has made any change in the legal position as regard the principles which emerged from various decisions and notice in Delhi Clause General Mills, rejecting both extreme contention and starting on the premises that the act is a beneficial piece of legislation enacted in the interest of the employees. It was held that although the legal right of the management to raise a preliminary issue and in the event was determined in favor of a workman to lead evidence for the first time before the tribunal, the labor code could not be denied open. The tribunal is now at liberty to consider not only whether the finding of a misconduct recorded by an employer is correct, but also different from the said, if a proper case is made out, what was the largely in the realm of the satisfaction of the employer has ceased to be so, and now it is satisfaction of the tribunal that finally decides the matter. It was furthermore held that therefore it will be seen that both in respect cases where a domestic inquiry has been held, as also in cases where tribunal considers the matter on evidence adduced before it for the first time, the satisfaction under section 11A about the guilt or otherwise of the workman concerned is that of the tribunal. It has to consider the evidence and come to a conclusion one way or other. Even in cases where an inquiry has been held by an employer and finding of misconduct arrived at, the tribunal can now differ from that finding in a proper case and hold that no misconduct is proved. Number para 27.
Yes.
While determining the issue as to whether the workman is guilty of misconduct alleged to have been committed by him or not, the workman would be entitled to raise all contentions, including the contents of lack of bona fide or unfair labor practice, and also act of victimization on the part of the management. Even the evidences in that behalf can be laid. Save and except, however, for sufficient and cogent reasons, neither the inquiry officer would arrive at a finding in regard to lack of bona fide of victimization or unfair labor on the part of the management. The labor court, while considering the said finding, would ordinarily not do so. Such question must be appropriately raised, and materials must be brought on record to establish the said allegations. It is one thing to say that the finding of the inquiry officer is perverse or betrays the well-known doctrine of proportionality, but it is another thing to say that only because two views are possible, the labor court shall interfere therewith. In other words, it is one thing to say that the basis of the materials on record, the labor court comes to a conclusion that the verdict of guilt has been arrived by the inquiry officer, where the material is suggested otherwise. But it is another thing to say that such verdict was also a possible view. Now, the finding is at para 34. The ratio of this. The upshot of our discussion is that the decision of the labor court should not be based on mere hypothesis. It cannot overturn a decision of the management on ipse dixit. It's the jurisdiction under section 11A of the Act, although is a wide one, must be judiciously exercised. Judicial discretion, it is right, cannot be exercised either whimsically or capriciously. It may scrutinize and analyze the evidence, but what is important is how it does so. So in the award your lordship has seen, my lord, the labor court, only because the management did not take part and it proceeded ex parte, labor court whimsically has set aside the order without arriving at any finding that the removal order is bad. The other judgment is of Allahabad High Court, page 12. One paragraph in that judgment, para 6, page 13. Labor court, while considering this matter under section 11(8) Industrial Dispute Act, had ample power to examine and appreciate the findings of the inquiry officer, including the right to appraisal of the evidence, which is on record. Section 11A of the Act abridges the right of the employers when it comes to awarding a punishment based on conclusion of a domestic inquiry. The labor court can alter the punishment imposed by an employer under section 11A of the Act if the misconduct is proved The labor court is entitled to hold the opinion that the order of discharge or dismissal of the said misconduct is not justified. It can then award to the workman a lesser punishment. Labor court has been given a power for the first time to interfere with the punishment imposed by an employer, but wide as this power may be, it hedged in by the proviso to section 11A of the act, which requires the labor court to take into consideration only materials on record. Although section 11A confers power on an industrial tribunal or a labor court to substitute a lesser punishment in lieu of the order of the discharge or dismissal passed by the management, this power has to be exercised judiciously, and industrial tribunal or labor court is expected to interfere only if it is satisfied that the punishment imposed is highly disproportionate to the degree of the guilt of the workman concerned. The power is akin one used in these cases where principle of proportionality is invoked. So, my lord, the entire record, the inquiry report, which is Exhibit 5, page 53 in the record, was before the
Exhibit J.
Exhibit J, page 53, was before the labor court. So, labor court without,
What is exhibit C?
my lord, Exhibit J is the inquiry report. It is a part of the report.
Yes.
The another judgment of Supreme Court at page 15, my lord. I'm relying on para 16, page 18. Mary.
Yes.
The labor court had earlier held that the inquiry was properly held and there was no violation of the principles of natural justice, and that the findings were not perverse. The vitiating facts found by the labor court against the inquiry are erroneous and are liable to be set aside. If the inquiry is fair and proper in absence of any allegation of victimization or unfair labor practice, the labor court has no power to interfere with the punishment imposed. Section 11A of the Act gives ample power to the labor court to reappreciate the evidence adduced in the inquiry and also sit in an appeal over the decision of the employer in imposing punishment. Section 11A of the Industrial Dispute Act is only applicable in cases of dismissal or discharge of a workman, as clearly mentioned in the selection itself. Before the introduction of Section 11A in Indian Iron and Steel Company versus Workman, this court held that the tribunal does not act as a court of appeal and substitutes its own judgment for that the management, and the tribunal will interfere only when there is a want of good faith, victimization, and unfair labor practices on the part of the management. There is no allegation of unfair labor practice victimization in this case. The powers of labor court in the absence of Section 11A is illustrated by this court in Workman, Firestone Tire and Rubber Company versus management. When inquiry was conducted fairly and properly in absence of any allegations of malafide, victimization or malafide or unfair labor practice, the labor court has no power to interfere with the punishment imposed by the management. Section 11A is not applicable. Labor court has no power to reapprise the evidence to find out whether the findings of the inquiry officers are correct or not, whether the punishment imposed is adequate or not. Of course, the labor court can interfere with the findings if the findings are perverse, but there is clear finding that the findings are not perverse and principles of natural justice were complied while conducting the inquiry. If your lordship, in the petition which has filed by the workman respondent number 5 under section 2A, there is no allegation of unfair labor practices, victimization, or malafide, or the findings of the inquiry report are perverse. So the onus is upon the workman who assails the order of removal.
All right. You finish off with your judgments, then we would like to have a look at the inquiry report.
My lord. On this point, my lord, the third judgment, my lord, page 20. It's a
Yes.
judgment of Punjab and Haryana High Court, my lord. One paragraph, page 25, I'm relying on paragraph 16. But I'm relying from the line, the punishment awarded at 13th line.
Yes. You order to a photocopy for
The punishment awarded was dismissal from service for proven gross misconduct and stoppage of 3 increment with cumulative effect for willful insubordination, disobedience, and lawful and reasonable orders of the superior. The labor code clouded as it was by a fundamental assumption that the disciplinary authority did not have the power to impose punishment. To be an officer below the rank of the appointing authority went on to the make sweeping observation that the evidence of the witness were contradictory and the report of the inquiry officer was not acceptable. No point of contradiction was ever elicited in the award. None of the reasoning of the inquiry officer has been put to any test by judicial appraisal and reasoning. The labor court did not appear to have considered any material for coming to a conclusion that the inquiry officer's findings were either perverse or incorrect. The labor court ought not to have interfered under such circumstances where the findings of the inquiry officer come disciplinary authority were appropriate and had considered all relevant aspects.
Yes.
Well, we come to the inquiry report. No? The inquiry report starts from page 71. Should I start from page 126? It's the overall assessment of the ODI. What if from first?
Yes.
Should I start from first page
Yes,
71?
yes. Let us have a look, complete view.
Well, the report in the matter of an inquiry against Sri Dinesh Chandra Dekha, SO, HOD Industrial Cooperative Bank, in respect of charge sheet dated 5/12/2012 issued to him by the Managing Director, Disciplinary Authority, the Industrial Cooperative Bank, SS Road, Laktokia, Guwahati. The undersigned was appointed as an inquiry officer to conduct a departmental inquiry in respect of the charge framed against the above officer by the Managing Director, while later dated 23/2/2017. The charge sheet and the statement of allegation dated 15/5/12/2012 against Sri Dinesh Chandra Dekha is enclosed under Annexure A. The plea of charge sheeted officer at the commencement of the inquiry proceeding on the first sitting of the inquiry on 7/3/2017, the CSO denied all the charges leveled against him, and the statement of allegation dated 5/12/2012. So, a full-fledged inquiry had to be conducted. The CSO, by its later dated 7/3/2000, requested the EO to hold the inquiry proceeding in abeyance, as he had made an appeal to the appellate authority against the appointment of the new inquiry officer for former inquiry officer, who conducted this inquiry and had passed an order that the inquiry proceeding had been closed. However, he was advised to approach the disciplinary authority, who is the competent authority to do so. However, his appeal was dismissed by the appellate authority and advised CSO to cooperate with the present EO by entering inquiry. However, he went to the Honorable Guwahati High Court, and the court, by order dated 7/4/2016, directed the bank EO to stay the departmental proceeding. The inquiry proceeding was stayed on 18/4/2017 and adjourned till further communication is received. The stay of the order of the Honorable Guwahati High Court was vacated on 23/6/2017 with a direction to complete the disciplinary proceeding within a period of 2 months from the date of receipt of a certified copy of the order. The chairman of the Industrial Cooperative Bank, by later dated 1/7/2017, which was delivered to me on 4/4/2017, advised me to complete the inquiry as early as possible, keeping in view of the stipulated time frame of 2 months as per the order of the Honorable Guwahati High Court, and further advised me that the inquiry proceeding conducted by the earlier EO may be taken into consideration, and all materials placed before the earlier EO may be taken into account while proceedings with the inquiry. The undersigned had given notice to the PO and CSO that the inquiry proceeding would be held on continuous basis with effect from 6 July 2017. There were 5 sittings between 6/7/2017 to 12/7/2017. The inquiry proceeding could not be held from 13/7/2017 to 21/7/2017 on account of CSO's illness, medical certificate produced, and the inquiry again started on 24/7/2017, 22nd, 23rd being holidays. The production, inspection, supply of documents from PO and defense were done during 5 sitting, and the process could not be completed due to non-availability of some documents, as some documents are being very old and not readily traceable. Observing large number of documents, which would have been 250 numbers, including exhibit computer display, I requested the bank's management by my letter dated 17/7/2002 make an appeal to the Honorable Guwahati High Court to extend the time at least another 1.5 months. However, I was informed by the head office that the further extension of that would not be possible as per their advocate's information. Till that time, 17/7/2017, I had the impression that I am to hold the inquiry from the beginning. However, on 18/7/2017, on second reading of the court's order 23/3/2017, I realized that I should have linked the operative part of the Honorable Guwahati High Court order dated 26/6/2017, clause 12, with reference to clause 11. The communication dated 11/8/2015 of the former EO that the inquiry was more or less complete. Thus, it was realized that we were to complete the disciplinary proceeding from the stage it was left by the former inquiry officer. However, this idea was further confirmed on receipt of WPC number 2193/2015 of the Honorable Guwahati High Court case filed by DC Deka, which was delivered by the HO on 19/7/2017 to the undersigned. The disciplinary authority was requested by letter dated 18/7/2017 to supply the original proceeding book along with the materials used by the former EO in the inquiry through PO on 19/7/2017. However, there was no sitting till 24/7/2017 as the CSO resumed office on 24/7/2017 and attended the inquiry proceeding. The CSO was informed that now onward the inquiry would be held from the stage the former EO had left the inquiry proceeding. On 25th July 2017, the PO informed that they are still searching the record of the former EO and would inform us as soon as it is available. On 29/7/17, the inquiry proceeding, the PO has brought the proceeding of an inquiry by a former EO with a forwarding letter dated 29/7/2017 by the secretary and requested to complete the inquiry expeditiously with prescribed time. The proceeding of inquiry sent by the former EO, Mr. A. Patasase, through email dated 19/8/2015 is produced before the inquiry copy of the same was also provided to the EO to go through it about 12:15 and to meet again at 3 p.m. The inquiry proceeding was started again at 3:10 and the PO submitted a list of documents used by the former EO. It was found that most of the document in this list of former EO was already made available to the CSO, EO, and the PO himself during the production, inspection, supply of document during 5 sittings between 6/7/2017 to 12/7/2017. Thus, 5 sittings held earlier found useful for the subsequent inquiry held from the stage left by the former EO. The PO and the CSO was allowed about 3 hours to go through the inquiry proceeding and the former EO. It was found that what was presented, deposed, examined earlier, we would not go back for re-examination. However, we may proceed further per direction given by the former EO. In the last para of his inquiry proceeding, it seems the former EO asked the PO and the CSO if there be a further materials with them, they may be produced if available to support contradict the allegation within 3 days. It seems there was a sittings after 25/7/2015. So PO and CSO was allowed to produce materials in support of their cases. The inquiry proceeding started with effect from 29/7/2017 from the stage the former EO had left. On the first day of the inquiry dated 23/9/2013 to a question by the EO to the CSO whether he admit the charge, the CSO replied that no, he did not admit the charge, so the EO conducted the inquiry. Requisite documents for defense and management were recorded in the proceeding of the inquiry and additional documents were subsequently provided to the defense as per record. The EO allowed CSO to defend his case by defense representative Asim Sarkar and the management appointed presenting officer JC Talukdar. In subsequent inquiry, after the first inquiry officer had left, the requisite document requisitioned by the CSO was provided in addition to a certified copies of the management document. The list of documents of the management and defense are enlisted in Annexure B and Annexure C, and the list of the documents enlisted by the EO, former EO in the proceeding of the inquiry enlisted in Annexure K. In subsequent inquiries started with effect from 29/7/17, the CSO was allowed to take assistance of an officer of the bank as is dear to defend the case. The CSO took his facility and Mr. Asim Sarkar, Officer 1, defended his case. However, the defense did not take any witness, but this case was presented by the DR. The documents and certified copies submitted by the PO were provided to CSO Defense, and CSO was allowed to inspect the same from the custodian of such document. The CSO said that the Xerox copy of the documents duly certified by the bank's official supplied to him would serve his purpose. However, in case of any doubt, he may be allowed to see the original, and it was assured that he may inspect any original or all as and when required. He also submitted the list of additional documents. The documents enlisted by the CSO were supplied by the PO, and he was allowed to go through the requisite files and obtain the copies thereof. During the progress of the inquiry proceeding, he was allowed to obtain additional copies of the documents for his defense. The CSO dear request for inspection of loan appraisal file of Alcon was not allowed on the ground that he inspected the same file once on 2/6/2015. However, it was found that the file was again inspected by him on 11/7/2017 and took 3 copies of the documents. If the defense needs only specific document, they could have requisitioned it instead of asking the same file time and time again, in sort of roving and fishing inspection, which is not permitted. During the inquiry proceeding, when half of the inquiry was over, the management presentation was over, the defense inquired whether they may take the inquiry proceeding by the former inquiry officer as original. It was informed that the management had supplied the proceedings of the former EO the way they have received from AK Bhattacharya, former EO, through bank's email, and with email forwarding from Ajay Kumar Bhattacharya on Wednesday, 19 August 2015, downloaded by the bank on 28/7/2017. The copy was sent to the EO through PO in the inquiry with a forwarding by the secretary of the bank dated 29/7/2017. The management has no other way but to take it as genuine. It is observed that the exact copy of the inquiry proceeding by the former EO was filed by the CSO in the Honorable Guwahati High Court, a copy of which was also received by me along with the other documents. During the inquiry proceeding, it was found that the exhibits referred and content thereof of the exhibit mentioned in the inquiry proceeding of the former EO found tallied with the same exhibit when physically produced supplied by the PO in the inquiry. The inquiry proper is held from the stage the erstwhile inquiry officer has left, started on 24/7/2017 and concluded on 14/8/2017. Management and defense documents. The list of management and defense documents exhibited in the inquiry proceeding are enlisted under Annexure B and Annexure C, and documents exhibited Part 1 of the inquiry erstwhile EO is marked K, Annexure K. It was informed to the PO and CSO that irrespective of the procedure adopted by the former inquiry officer in conducting the inquiry proceeding, now rest part of the inquiry will be conducted as per the staff service rule of the Industrial Cooperative Bank, Chapter 6, Employees Discipline and Appeal Rules, and brief outline of the sequence of the inquiry proceeding was elicited in the inquiry proceeding. Written brief of the PO and the DR CSO. The PO has submitted his written brief to the EO on 24/8/2017, and a copy of the same was received by the DR CSO on 25/8/2017. The written brief are enclosed herewith, which were taken into consideration when warrants in evaluating the evidence thereof. The inquiry proceeding conducted by the AK Bhattacharya may be marked as Part 1 and by JC Das be marked as Part 2. The following abbreviation are used in the inquiry report, which may be noted accordingly. These are the list of documents.
You can skip that.
I'll come to the overall assessment
Hmm.
of the OD account.
Where is the finding? Yes.
Page 126. These are the assessment of the overdraft account, which are these part of the charges leveled against the CSO.
Yes.
The CSO in his self-explanation at the end of the inquiry deposed that some customer approached the MD for excess drawing. MD had verbally and sometimes in writing advised the branch manager to allow OD. As per instruction of the MD, the CSO obliged. He also further deposed that the former EO in his inquiry proceeding Part 1 observed that it is just a practice of the bank, but violation of instruction may tantamount to gross misconduct. It is not known whether the customers requested MD verbally or written for excess drawal. Did MD do not keep any record that the customer made such request? It is strange things on verbal basis. The question of the former your observation, the record of PO GC Talukdar is in the context of countersigning of the check, which was already addressed that the other officer signed the check to verify the apparent tenor of the instrument that the check is correctly drawn. It is noted that while lawful orders of the superior is to be obeyed, but unreasonable and unlawful order, if not obeyed, it will not amount to disobedience and insubordination and not come under the gross misconduct. It is to be noted that the CSO deposed that the MD sometimes gave instruction in writing to allow access drawal. It is to be noted in the inquiry proceeding, the defense could produce only one such written order for the OD account allowing encashment of limit as well as TOD, exhibit number EX, account Kamrup Minerals and Chemicals Private Limited. The maxim that is wrong in one thing, wrong in everything is neither a sound rule of law nor a rule of practice which may be noted. The defense representative in the presentation of their case and the PO in the cross-examination of DR asked if the excess drawing over sanction limit is a practice, and if this practice is a wrong, whether the CSO would follow the wrong practice or rules of the bank, to which the DR deposed that we follow the rules of the bank. However, allowing excess drawal as per instruction of the higher authority to select borrowers is reflected in a ledger computer statement OD account. However, such practice was stopped after the entry bar was imposed. The defense in their written brief, page 7, stated that the system came into force when the CSO was relieved from the branch. The entry bar was imposed on 1/1/2010 and the CSO was relieved from the branch on 9/10/2010. And the CSO allowed excess drawal on 1/10/2010 to the Kamrup Minerals Chemicals at the written instruction of the MD. Without referring to MD, his circular MEX 08, that entry bar was in force, whether he should allow against his direction in MEX 08. The practice of allowing excess drawal beyond one's authority is a wrong practice, and it has come to the record of the inquiry that on account of the following wrong practice, the predecessor of the CSOs at Guwahati branch was charge sheeted by the bank. The defense also presented 7 numbers of OD account where his predecessor allowed excess drawing. The board has imposed entry bar to stop wrong practice and later on took action against erring officials. The PO in his written brief regarding entry bar stated that it was seemed when the large scale irregularities came to the notice of the board of directors, the entry bar stopping the irregularities of allowing excess drawing in OD accounts was imposed as MD did not take any action for reasons best known to him, action initiated by the next MD. It is found that the assessment of the OD account, when particular OD accounts after having allowed excess drawal over sanction limit continuously, it reached a stage when the borrower can no longer bring the excess drawing within the sanction limit, and to cover up this irregularities, the limit is enhanced. In case of OD account of Elkan, the debit balance reached 301 lakh on 15/9/2010 against the limit of 90 lakhs. Does it exceed limit by 211 lakhs? Though the position of irregularities was known to MD, no explanation question was asked to the branch manager by letter to the chairman wants to justify the excess drawing in his OD account, and that every year party had been enjoying overall sanction limit over the sanction limit more than crores, and by the departmental payment reduced the balance up to sanction limit. But this is patently incorrect, for the party's debit balance in OD account never reduced to the sanction limit as evident from the firm statement of the OD accounts. Messrs. Elkan, it is not certain whether the above letter was produced before the chairman, as there is no comment on this letter and any note given by the chairman on this count. No evidence was brought before the inquiry that the chairman had received the letter and his comments thereof. When a party was not in a position to bring the debit balance of 301 lakh as on 15/9/2010 to sanction limit of 90 lakhs, in order to cover the irregularity, the limit was enhanced from 90 lakhs to 150 lakhs on 25/9/2010. But before enhancement of limit, the debit balance 301 lakh was brought down to 201 lakh by transferring 100 lakh from Elkan project, a sister concerned same group to which loan was granted during the time of enhancement of Messrs. Elkan DX06, that is property already mortgaged to Messrs. Elkan, to be extended to Messrs. Elkan project. The turnover is declining trend, and turnover was about 29.78 crores during the year ended 31/10/2009. The turnover of his OD account was about 492 lakh during the year ended 31/8/2010, which does not qualify for the limit of 150 lakh. Even by enhancement of limit to 150 lakh, the debit balance could not be brought down to the sanction limit. The limit stood at 204 lakhs. As on 29/10/2010, it remained irregular. The CSO and the MD was aware of the irregular nature of the OD account. The OD account of Messrs. Golden Tea Houses Export had debit balance of 1.82 lakh against a sanction limit of 90 lakhs as on 30/06/2010. That is, excess drawing was 92 lakhs and the transaction in the OD account was nominal and on declining trend. The debit balance was brought down to 149 lakhs by transferring 20 lakhs from its sister concern, same group, Messrs. Golden Tea House, and 13.60 lakhs was credited from proceeds of 2 numbers of RD account of the party. When the party was not in a position to bring the debit balance within sanction limit of 90 lakhs, the limit was enhanced to 150 lakhs on 3/10/2010, and the turnover in the OD account was about 198 lakh for the period 19/2008 to 29/9/2010, which hardly qualify for a limit of 150 lakh on 3/10/2010. Messrs. Golden Tea House, the MD, by this letter dated 9/3/2009, requested the party Golden Tea House to deposit excess amount over the sanction limit within 25/3/2009. It is to be noted debit balance in OD account was 1.61 lakh against the limit of 50 lakhs. When the party could not bring the balance to sanction limit, the limit was enhanced to 90 lakhs on 31/3/2009 by Messrs. LRSC, and the limit was ratified by the BOD on 14/5/2009. The debit balance in the OD account was 1.18 lakh, which is also excess over the limit. Thereafter, after the enhancement of 90 lakh on 14/5/2009, the OD account remained irregular till it was again enhanced the limit to 150 lakh on 3/10/2010. Thus, the both CSO as well as the MD was aware of the continuously aware of the irregular nature of the OD account. The details of the case OD account Messrs. Kamrup Mineral and Chemicals is as follows. The debit balance in the OD account of Kamrup Mineral Chemicals on 30/9/2010 was 60.47 lakhs against a limit of 30 lakhs. It was already an irregular account. The MD, in an usual way, by this handwritten letter 1/10/2000 to the branch manager, allowed TOP of 75 lakhs, out of which 15 lakh was for 10 days up to 11/10/2010. It seems by enhancement of top rupees 75 lakhs, rupees 15 lakhs for 10 days only, equal to 60 lakhs. Someone interested tried to cover the irregularities of this OD account having debit balance of 60.47 lakhs on 39/09/2010 against the limit of 30 lakh. The CSO complied the request of MD's letter dated 1/10/2010 and advised his branch manager on the bodies of the MD's above letter to do the needful. Accordingly, 2 numbers of check amounting 8.5 lakhs and 6 lakhs, total amount of 14 lakhs, was paid in cash through this OD account. It seems that MD had allowed this to OD on the basis of the feedback from the branch that the party's proposal for enhancement was under process at branch, because the proposal is first processed at the branch level and the CSO was quite aware of it. The CSO complied the request of the MD and paid the above check without referring to the MD that there was an entry bar restricting further overdrawing of overdraft account. In the inquiry proceeding, part 1, page 5 and 6, the CSO deposed for modifying, extending the credit limit, documents, papers like application, position of the account, turnover position, present outstanding balance of the account are some of the papers with forwarding recommending letter to be sent to the HO under joint signature, including the branch manager. When asked by the EO when there is any chance of concealment of fraud in such situation, the PO said that in positive yes. It is to be noted turnover of the account is one of the factors in determining limit. In the guidelines and procedure of loan, MEX 05 enhancement of existing limit of OD and CC, it is stated that the branch manager, after proper verification of the account and reason for enhancement of the loan, if convinced, may be forwarded with the detailed note that is to the HO/head competent authority. The following OD limits were enhanced during the tenure of CSO at Guwahati Branch. Messrs. Elkan, year ended 31/10/2009, turnover statement 29.05 crore. Messrs. Elkan 31/8/2010, 4.292 crore. Limit enhanced with date 150 lakhs on 25/9/2010. Messrs. Golden Tea House 31/10/2009, turnover 3.30 crore. Messrs Golden Tea House Export 31/10/2009. Turnover statement of the OD account 1.54 crore. Messrs Golden House 31/8/2010. Turnover 84 lakhs. Limit enhanced up to 150 lakh on 3/10/2010. All the above three numbers of OD account were highly irregular overdrawn continuously throughout the year, with transaction in declining trends. Referred statements of OD accounts and Exhibit 83, Exhibit 84, 85 with much reduced turnover do not qualify for enhancement of limit to the above extent. It seems adverse features of the above OD account were not highlighted by the branch manager while forwarding the enhancement proposal. The MD was aware of the position of the OD account, yet he got this OD account approved at the board. When he came to know that the adverse position of the OD account, he did not ask for any explanation from the CSO for large-scale irregularities, but covered the irregularities by enhancing the limit unusual way as elicited. From the above large-scale irregularities running for years and the CSO's assertion that he allowed this overdrawing at the instruction of the MD, it follows that when the CSO allowed improper excess drawing of money from the OD account of the bank through party's OD account on the instruction of MD, the CSO knowingly lent himself to be a party to the collusion and conspiracy, and the fact that the money excess drawing was allowed to be withdrawn at the instruction of the MD is not an exonerating factor. It is already adduced that the MD had no power to allow excess drawing beyond his lending power, which is rupees 3 lakhs only. It has already adduced in the inquiry report under OD Elkan that on a single day CSO allowed excess drawing of rupees 56.8 lakhs by passing 9 numbers of checks. This excess drawal was beyond the power of the MD, chairman of the bank. The general refrain of the CSO is that he allowed excess drawing as per the verbal instruction of the MD, but the MD's sanctioning power is 3 lakhs only. As per rules, greater credence is to be given to men's act than to their alleged words. The CSO allowed the excess drawing by passing 9 checks amounting rupees 56.8 lakhs is an established hard fact. The irregularities cannot be cured that he allowed on verbal instruction of MD who has no such power. It is sound principle that no one can give what he does not possess, and in this case, MD cannot give such instruction. It is to be noted that the board in their wisdom allow only 10% of overall over sanction limit to the parties maintaining financial discipline, and not 121% excess drawing by CSO in the above case. Because the welfare and the protection of the institution is supreme in their mind, the above acts of the CSO are not an innocent and casual mistake during the course of the performance of the official duty. It is obviously done as a concerned action prejudicial to the interest of the bank. What has been assessed in the preceding pages, now it has been concluded as follows. On the basis of the allegation as contained in the charge sheet dated 5/12/2012, Annexure A, the Managing Director Discipline Authority has brought following charges against Sri Dinesh Chandra Deka, CSO. You had, in performance of your official duty, acted prejudicial to the interest of the bank, committed gross negligence involving or likely to involve the bank in serious loss, which constitute major misconduct on your part, as per Staff Service Rule number 36, Roman 10. The allegation made by the Managing Director Discipline Authority contained in the charge sheet, which have been duly assessed by the undersigned in the inquiry, and on the basis of the finding in the inquiry against respective allegation in this report, I hold that the above charge of misconduct leveled against Dinesh Chandra Deka proved. This finding of the charge sheet dated 5/2 issued by the Managing Director against Dinesh Chandra Deka of so and so so and so.
So was there any actual loss to the bank?
Yes, sir.
What is the nature and extent of such loss?
Hmm?
213.96
2
crore.
crores 13. 2 crores 13 lakhs. Malak.
Where is that finding?
That finding is not there in this report.
Malak, that finding is not.
2 crore 13 lakhs.
2 crores 13 lakhs.
1-3.
My lord,
1-3. 2
1
crore.
3.
Yes. Now, please point out the order which was issued ultimately, removal from service. Where is
Hello.
that order?
That is at page 193. Eight to 2018. Mary.
Yes.
The departmental inquiry was held against Sri Dinesh Chandra Deka, senior officer grade 1, now senior management grade, the Industrial Cooperative Bank, in terms of articles of charges and statement of allegations dated 5/12/2012. On being satisfied with the so-called reply filed by the Dinesh Chandra Deka against the articles of charges and the statement of allegation, it was decided to inquire the matter by appointing inquiry officer as per staff service rules of the bank. Initially, Ajay Kumar Bhattacharya was appointed as the inquiry officer, but later on, he was substituted by Sri Jogesh Chandra Das. The inquiry officer, after conducting the inquiry, submitted the report dated 22/9/2017, holding the charge of misconduct leveled against Sri Dinesh Chandra Deka has been proved. Thereafter, he was furnished with the inquiry report along with second SOCOS notice dated 30/12/2017, asking him to SOCOS as to why he should not be removed from service. Again, the second SOCOS notice, Sri Dinesh Chandra Deka submitted his reply on 29/1/2018. The charge sheet, SOCOS reply, the inquiry report, and the second SOCOS reply were perused. On perusal of all the relevant documents and report, it is found that Dinesh Chandra Deka, senior officer grade 1, acted prejudicial to the interest of the bank and committed gross negligence involving or likely to involve the bank in serious loss, which constitute major misconduct in his part. Since the charges of the misconduct level against Dinesh Chandra Deka, senior officer grade 1, have been proved in the inquiry, the retention of his service in the bank will be detrimental to the interest of the bank. Therefore, it has been decided to remove Dinesh Chandra Deka, the senior officer grade 1, from service with immediate effect as per clause 26 and 27 of the staff service rules of the Industrial Cooperative Bank, clause 34 and 36 of the earlier staff service rules. Accordingly, Dinesh Chandra Deka, who is working as a senior officer grade 1, is hereby removed from his service with immediate effect. If you
So on the face of this order, the respondent approached the labor court,
respondent approached the labor court.
directly approached the labor court.
Yes, the respondent first approached the labor commissioner for initiating a conciliation proceeding. We were served the notice. In the notice, we contended that he is a officer of a senior grade. He doesn't come under the definition of workman, and so no conciliation proceeding was initiated. Thereafter, page 198, he filed an application under section 2A before the labor court, challenging the removal order. And in the application also, my lord, if your lordship will find, there is no case made out of victimization, unfair labor practice, or saying that in the departmental proceeding he has not been given opportunity being heard, and the findings of the inquiry report are purpose. Nothing, my lord.
But Industrial Cooperative Bank Limited, it's an other authority within Article 12.
It is, my lord, it has a control by the RBI, my lord.
By the?
RBI, this Reserve Bank of India. And right now, my lord, there is no management. It is controlled by an administrator appointed by the RBI.
No, a writ petition will lie against this. That you are not sure.
My lord, writ petition, in my humble submission, it will lie, my lord. If a case is make out that there is a procedural lapses and the
No, that's the ground.
Well,
Even if without no procedure, whether a writ petition will lie or not is another thing.
well,
It doesn't depend on how strong or weak a person's case is. Has the state got any control over this bank?
Reserve Bank of India has got a control. over it.
You don't know, or you are just guessing?
No, Malad, Reserve Bank of India has the control. Malad, the recent administrator who is representing the bank at page 22, Malad,
Hmm.
has been appointed by the Reserve Bank of India. Because of several financial irregularities and malfunctioning, Malad, on the part of the management, in connivance with this, Malad, respond number 5.
Hmm.
But the bank had suffered a loss, and page 22, Malad,
Yes.
the Reserve Bank of India being satisfied that in the public interest and for preventing the affairs of the Industrial Cooperative Bank being conducted in a manner detrimental to the interest of the depositors and securing the proper management of the bank in collaboration with the state government, found it necessary to supersede the board of directors of the Industrial Cooperative Bank and also to have an administrator appointed thereof.
Just one second. All right.
Well, the other day, the ground which has been argued by my senior friend as to that there was a reference pending at the time when the removal order was passed.
Hmm.
Now, in the affidavit, they have brought the
Reference pending where?
in the labor code, which was not connected to the issue. Well, this is a disciplinary proceeding which has been initiated in 2012 itself.
Against him, same person.
The instant disciplinary proceeding wherein Q has been removed. A reference was instituted by a notification of 2017, where one issue with regard to his suspension was an issue before the labor court in that reference case. Now, in the suspension, at the time when this order was passed by the
Yes.
labor court, the reference was disposed on 7/5/2018. Lordship takes up the affidavit filed by the respondent number 5 at page 242 is the judgment of the award of the labor code in reference case number 12/2017. They try to point out that there was a pending reference at the time when the removal was done, when the removal order was passed. And therefore, under section 33, without taking the approval, that order of removal is inoperative. Now, my lord, my humble submission, my lord, that one issue with regard to his suspension, he was suspended during the pendency of the departmental proceeding. That was put to challenge before the Honorable High Court. The Honorable High Court revoked that suspension order, directed to continue with the disciplinary proceeding. Now, the day when the judgment, the reference was disposed, at that point of time, the issue with regard to suspension was no more alive. And therefore, the labor court very rightly has decided that issue in negative. So, in my humble submission, my lord, 33 would not come in. And it is not also their case that for violation of section 33, they had approached the labor court under section 33A. Section 33A says, my lord, if there is a violation, a complaint has to be filed before the labor court that there is a violation, and in violation of that section 33, a removal order has been passed. And they have to make out a case of unfair labor practice and victimization. But there are judgments of Honorable Supreme Court where it has been said the charges of unfair labor practice and victimization are serious charges. It has to be pleaded and proved. And therefore, my humble submission, my lord, that section 33, the bar, the ban on of the intention of section 33(2) is that to prevent unfair labor practice and victimization during a pending reference. Well, that will not come.
Yes. Anything else? So to
That's all.
conclude and to sum up, what is your basic prayer here?
My lord, we have challenged the award, the consequential judgment under section 33C, whereby the labor court has computed the back wages and the proceeding of Bakizai proceeding initiated for recovery of the amount.
No, no, where is the judgment under 33C?
Section 33C judgment, your lordship will find at page 218.
It is a consequence of the award, my lord. The award entitles him for the back wages, and the back wages has been computed as 35,76,909, page 219, second last paragraph, my lord.
Yes.
Well, so in my humble submission, my lord, the award lacks jurisdiction first, my lord. And assuming, my lord, the jurisdiction point is not taken, my lord, as it has been decided earlier, and we did not challenge. Then also, my lord, this award, my lord, the labor court failed to exercise the power that has been conferred under section 11A and has whimsically set aside this order, my lord, which is apparently, my lord, wrong, my lord. That's right.
So are you suggesting that this order should be set aside and the matter should be remanded for a fresh decision?
I think, my lord, that will protect the interest of both. My lord, then the maintainability issue can also be taken up by because that as a preliminary issue, it has not been taken up. We can always raise that maintainability issue.
Let us see what he has to say.
My lord.
May it please the lordship. The lordship has seen that they, at the very first instance, raised a question of maintainability on the ground that he is a manager. Lordship has also seen the order of 22/4/19. What was the direction given by the labor court? Labor court held that whether a person is a manager or not, it is a mixed question of law and fact, because the designation will not decide the issue as to whether he is a workman or not. Accordingly, it was rejected and they were given the liberty to file the written statement and take up this issue and adduce evidence. They have not done that. They have not challenged that order, as your lordship has rightly pointed out. They have not filed their written statements setting out that these are the duties he was doing for which he is not a workman. Now, why I am saying, my lord, if your lordship takes up the industrial dispute rules, when a reference is made, notice is served on the other side, there is no scope of filing piecemeal petitions. One has to file the written statement taking up all the pleas. Lordship, for that moment, I would like to refer your Lordship to Rule 10B of the Industrial Disputes Rule. So there is no provision for filing a petition raising the question of maintainability. That issue has to be taken up along with the written statements, industrial dispute rules.
Central rules.
Yes, ma'am. Well, referring an industrial dispute for
Which
adjudication,
rule number?
rule number 10B.
Yes.
While referring an industrial dispute for adjudication to a labor court, tribunal, or national tribunal, the central government shall direct the party raising the dispute to file a statement of claim complete with relevant documents, list of reliance and witnesses with the labor court, tribunal, national tribunal within 15 days of the receipt of the order of reference, and also forward a copy of such statement to each one of the opposite parties involved in the dispute. The labor court, then 2, the labor court, tribunal, or national tribunal, after ascertaining that the copies of statement of claim are furnished to the other side by the party raising the dispute, shall fix the first hearing on a date not beyond 1 month from the date of receipt of the order of reference, and the opposite party or parties shall file their written statement together with the documents, list of so and so and so and so. So, my lord, once notice is served, the opposite party will have to file their written statement. And in that written statement, they are at liberty to raise all issues, including the issue of maintainability. Because they will have to project that this person is not a workman because he is doing these are the duties assigned. So, labor court rightly, my lord, by the order dated 22/4/19, rejected their petition raising the question of maintainability, and liberty was given to them to file the written statement and adduce evidence, which they did not. Now, my lord, why I'm saying that the designation will not decide whether a person is a workman or not. The test is the nature of duties. First, my lord, I have given the judgments, my lord. Lordship may take that 2006, 6 SCC 548. No, it is today I have given, my lord. 548. Lordship may directly come to paragraph 12, 13, 14, 15, and 16. Paragraph 12 quotes the definition of workman, which your lordship has already gone.
Yes.
Paragraph 12, the section, I will not trouble your lordship. 13, the ingredients of definition of workman must be considered having regard to the following factors. Now, my lord, 14. For determining the question as to whether a person employed in an industry is a workman or not only the nature of work performed by him, but also the terms of employment in the job performed are relevant considerations. Supervision contemplates direction and control. While determining the nature of work performed by an employee, the essence of the matter should call for consideration. My lord, this is very important. An undue importance need not be given for the designation of an employee or the name assigned to the class to which he belongs. What is needed to be asked is as to what are the primary duties he performs for the said purpose. It is necessary to prove that there were some persons working under him whose work is required to be supervised, being in charge of the section alone, and that too in being small one and relating to quality control would not answer the test. So, my lord, my understanding of this judgment is, if a person is considered to be excluded from the definition of workman, the party alleging must plead with the duties. Mere designation, my lord, that he is in such and such designation must.
Mr. Chakraborty, you see, I followed what you are trying to canvass. but please also address the court on this.
My lord,
Your client was admittedly holding the post of chief manager
my lord,
on the day on which the labor court reference was made. correct?
yes,
And that is a post which is, according to them, next to the managing director. That means according to them. Now, there is a service rule which is applicable to the employees. That service rule in chapter 2, as he has pointed out, lays down the various categories of employees, their rank, their designation, the nature of their duty. Everything.
no, my lord, nature of duties is not given.
Yes, it is given. That's why I'm saying.
Please.
7,
Yes, yes. Categorization. of
category
employees.
designation.
Then there is called Chief Manager HR Administration Stroke Credit and Development.
My
So
lord.
your client was holding the post of Chief Manager HR and Administration, correct? Now, if you say that administration means nothing to administer, administration will automatically involve a role which will involve looking after the work of involving other employees in a particular section or branch or division or whatever. A loaner cannot administer anything. There's no need to prove that. Now, if you say that this service rule is wrong, or there was a document or some authorization to your client to discharge his duties, dehost this service rule, then the matter is different. Otherwise, the moment it says that senior management grade, management, is it not enough to indicate that he is supposed to manage? You can't be in the management grade doing clerical work.
My lord, in the evidence, he has stated,
No, we'll come to evidence later. A person in the management, which the rules also say he is in management, and it also notifies or clarifies that he will have role in administration. You are saying unless they produce evidence, it should be treated that he is a clerk. You can say the
He's a
same
workman
thing
category.
in the same thing. You can say that for the managing director also. Did the managing director was also a workman? Correct, is it not?
my lord, what I have understood from the other judgments also,
Hmm.
whenever you raise this question, a person is not a workman, it is incumbent upon you to narrate the duties which he is performing.
So you have nothing to do. You can just simply say that I am a workman. and
Yes, it is their burden to establish that I am not doing the works which are normally done by the workman. It is the work you are doing, these are the works. Because this judgment says that undue importance to the designation and class or category should not be given. It should be decided.
That's correct. That's all right.
It should be decided. It may so happen, I am designated as chief manager or a branch manager, but if I do not have the power,
So what was the nature of your job? Have you stated it?
my lord, this question was never pleaded by them.
That
But in the
Very
evidence in
different.
affidavit, my lord, in the evidence in affidavit, it was stated that I was not given any administrative or such power
Where
that
is
we have stated.
Where is that? Page numbers?
My lord, I'm coming one. Page number 206. And my lord, this part of the evidence was not cross-examined and has gone unrebutted. Paragraph 2. I was entrusted with clerical works of the bank. No financial, administrative and supervisory power is allowed to me by the bank management and categorized me as a staff under the provisions of the staff service rule. So what he is trying to say, though I am designated as branch manager or chief manager, but I was not given any financial, administrative and supervisory power. So this part of the evidence,
No, you see, para 2, what he says is something else. He says, I was under the control of someone.
No,
He
no,
does,
there
he
are
does
two
not say
parts,
that
my
I
lord.
did not control anyone.
My lord, there are two parts.
Hmm.
That I first, it starts with that I was entrusted with clerical works of the bank. Full stop.
Hmm.
No financial, administrative and supervisory power was allowed to me by the bank management and categorized me as staff under the provision of staff rule of the bank.
Hmm.
Full stop. As per the service rules, I am liable in all respect of my work before the secretary, director, managing director and chairman of the bank. I was then another thing, I was entirely under the direction. So first three part that I was, though what he is trying to say, I was designated, but I was basically doing the job of a clerk. I was not having any financial power, that is a power by which I can bind the company or the branch. I do not have the administrative power, that is to control, and supervisory power. These things, it is there in the affidavit. They have not cross-examined me. They have not brought on record contrary materials, which now they are before your lordship. What they are doing now was not there in the label. This staff rule or the nature of duties assigned to that particular category of employee staff was not laid before the labor court. And my lord, why I am saying there are other decisions, I will refer to those decisions, which the trend is that the designation should not be given importance.
That's correct. That's correct.
So this part of that evidence was not rebutted or contrary materials placed. That order of 22/4/19 was passed. They have not challenged that. They have not filed the written statements pointing out the duties I was doing. So after getting the opportunity, there is a procedure prescribed in an industrial dispute adjudication. They were given the opportunity. They failed to avail that opportunity. And these materials were not before the labor court, in spite of the opportunities given. So it is too late for them to dig that issue. And even the writ petition, my lord, they have not challenged the writ petition on the point of jurisdiction. They have challenged the award on the point of 11A. They have challenged the order because the award is bad. The subsequent 33C2 order, there is just a passing reference is a manager. But in the writ petition, there is no ground taken that the award is bad because the labor court did not have the jurisdiction. That ground is not there, my lord. Now, my lord, another aspect why I am saying he is a workman. Lordship has seen the earlier reference. In that reference, 4 issues were referred. One, Lordship may come to 242 of my affidavit.
Yes.
The award, in that award, 4 issues were referred.
242.
242 of my affidavit in opposition.
That is page 20 of your affidavit in opposition.
My
What
lord,
is the internal page number?
it is internal 21. Just after the affidavit.
Yes.
Issue number 1, whether the management of Industrial Cooperative Bank Limited is justified in changing the conditions of service in terms of extension of hours of work and enhancement of rate of interest in respect of staff loan customary privilege without issuing appropriate notice as prescribed under 9A of the Industrial Disputes Act. Number 2, whether the management of Industrial Cooperative Bank Limited is justified in deducing the wages of section of workmen employees for 1 day, that is on the day of alleged illegal strike on 25/8/16, and making payment to other employees after forcing them to sign a good conduct bond. Third is my lord, whether the action of the management of Industrial Cooperative Bank Limited is justified in suspending Sri DC Deka. My lord, he is the respondent number 5. Its employees and General Secretary of Industrial Cooperative Bank Employees Association. My lord, here I would like to draw your lordship's attention. They are saying I'm the manager. I was designated as a manager, but I'm saying that I was not given any managerial power. The record says that I was the secretary of the Employees Association, which raised that earlier dispute. Which includes an issue of my suspension. And number 4, whether the management action of the management of Industrial Cooperative Bank Limited is justified in allowing office bearers of Industrial Cooperative Bank Workers Union to represent the management in the conciliation. So there's another issue. Now, my lord may come to page 249. Of the award when the issue number 2 was decided by the labor court. The internal page 8 of the reference award.
Yes,
Is a lot of paragraph 15.
yes.
May I read, ma'am? The management's plea is that issue number 2 is a vague issue as because in the reference, the number of employees from whom the bank deducted the salary has not been cited. The facts behind this issue are that being aggrieved by the suspension of General Secretary of the Association, that is the respondent number 5, the employees of the bank observed one-day strike on so-and-so. There is no dispute that the management took action against the striking employees by imposing a penalty of deduction of one-day salary. The General Secretary of the Association brought this notice issue before the Assistant Labor Commissioner so-and-so through so-and-so. The minutes of so-and-so, which has been exhibited and Exhibit E, speaks that the employees all who admitted their guilt and assured the management of not taking part in any future strike, the penalty levied from the striking employees was returned back. Now it is very important. There are 9 workmen, including the Vice President, the General Secretary, and the office bearer of the association who refused to confess their guilt. So, my lord, in that award, the court has recorded a finding. There are many employees, some of them who admitted their guilt and tendered apology, they were refunded the money. But 9 persons, workmen, this is the word workmen, including the Vice President, the General Secretary. So, my lord, in this award also, the General Secretary, that is the respondent number 5, was considered to be a workman. Bank in that reference contested the case. They have contested the issue, all the issues, including the issue of my suspension. So this is a finding in that reference. So where I was considered to be a workman. Now this award has not been challenged. This award has not been challenged. And the issue of my suspension is connected with the departmental proceeding. Rightly or wrongly, my lord, this honorable court directed my reinstatement by setting aside the suspension order, but this issue was also there. Management contested that reference. And I was not alleged to be a person who is not a workman. So, my lord, my submission before a lordship is this award, the finding where the General Secretary of the association is considered to be a workman by the labor court has not been challenged.
All right, Mr. Chakravarti, let's move on. Tell me how this award can.
My
be
lord, there is
sustained
another
on
aspect.
merit.
This
Please tell me.
11A, I will not address your lordship because before that, I am coming to, on the other day, I'll address your lordship on the issue of 33, which says that if a reference is pending and during pendency of the reference, if you want to dismiss or remove or discharge any workman for any misconduct not connected with the reference, then you have to seek approval. And once again, I'm drawing your lordship's attention to section 33. Conditions of service, etc., to remain unchanged under certain circumstances during pendency of proceedings. So the lordship has got it.
Yes, yes.
Now, 33 says, number 1, 33(1), during the pendency of any conciliation proceeding before.
You are reading 33 of industrial dispute.
Yes, my lord. 33.
33C, is it?
No, not C, my lord. 33. 33C
All right,
comes much later, my lord.
yes.
Condition of service to remain unchanged under certain circumstances during pendency of proceedings. So the lordship has got it.
Yes, please.
33(1). I'll not rely on 33(1). I'll be relying on 33(2). But for the understanding of the lordship, I'm referring to 33(1) as well. During the pendency of any conciliation proceeding before a conciliation officer or a board, or any proceeding before an arbitrator, a labor court or tribunal or national tribunal in respect of an industrial dispute, no employer shall, in regard to any matter connected with the dispute, alter to the prejudice of the workmen concerned in such dispute, the condition of service applicable to them immediately before the commencement of such proceedings, or for any misconduct connected with the dispute, discharge or punish, whether by dismissal or otherwise, any workman concerned in such dispute, save with the express permission in writing of the authority before which the proceeding is pending. Now, my lord, I'm trying to explain your lordship. Situation 1, a reference is pending. If the management or the employer wants to dismiss a person for any misconduct connected with that reference, then the management will have to take permission of the court or the authority before which it is pending. So, permission. 33(2)(b) speaks of approval. Lordship will appreciate permission and approval are two things. Permission means it is prior permission. You cannot do that before you get that permission. And approval is you can do that, but it has to be approved by the authority. 33(2), it says, during the pendency of any such proceeding in respect of an industrial dispute, the employer may, in accordance with the standing orders applicable to a workman concerned in such dispute, or where there are no such standing orders in accordance with the terms of the contract, whether express or implied between him and the workman. 33(a), I'm not bothering your lordship. B, for any misconduct not connected with the dispute, discharge or punish, whether by dismissal or otherwise, that workman, provided that no such workman shall be discharged or dismissed unless he has been paid wages for 1 month and an application has been made by the employer to the authority before which the proceeding is pending for approval of the action taken by the employer. My lord, here is a case. Lordship has noticed that a reference was pending on the day on which he was removed. And the issues of the reference are, first, whether the action of the management in discontinuing the customary privilege and changing the working hour is legal or not. Whether the dismissal, suspension of this workman is valid or not. 3, my lord, whether the action of the management in taking 1 day's salary from some employees and returning to some employees valid or not. So a reference was pending. Now, the misconduct, alleged misconduct for which he is removed is not an issue before the labor court, but a reference is pending. That is why, my lord, it was incumbent upon them to take approval from the labor court. Where the reference?
What will be the consequence of not doing it?
They have not taken approval. They have not filed an application. Consequence is, my lord, I have on the other day referred that constitutional bench judgment. It says that if you do not apply for approval or if the approval is not granted, then the order of removal or termination will be treated as unoperative and ab initio void. Once again, I will draw your lordship attention to that judgment.
No, he will, it. Officer or assembly. Or nine, and a single bench 115 is right. Come on, Mati Doksu, this court is rising at 1:15 today. Will you be able to conclude today?
My lord, 15 minutes it will not be possible.
Okay, okay.
Because I'll be addressing your lordship on this. I'll not be troubling your lordship on the issue of 11A. My case is not under 11A. My case is, I am opposing their writ petition on 3 grounds. First, my lord, there is blatant suppression of material facts and there is an attempt to mislead this honorable court. Because their whole case is that the management of Industrial Cooperative Bank was not aware of the award. And they came to know only when they received Bakijai notice from the officer. It is an incorrect statement. They have tried to mislead your lordship by explaining the delay for not coming to the court at the right time.
No, Mr. Chakraborty, see, so far whatever you have argued, let's sum it up this way. Your first contention is whether or not the respondent number 5 is a workman. This matter stands established from the materials on record, and that for that you are referring to the earlier order passed in the earlier
Award
case, award part, wherein he has been referred to as a workman. And you said that it was a contested matter, they never raised an objection. Second contention is that since the labor court has held that this is a mixed question of law and fact, you file your written statement. There was an opportunity for the management to take up this issue and establish that you are actually not a workman. They have not done it and that order has not been assigned. Therefore, this aspect of the matter cannot be reopened now. This is one point. Next, you are saying that since there was a reference pending, which ultimately culminated in that award passed in 2017. During the pendency of that, the second reference in respect of the order of removal or the order of removal itself could not have been issued, altering the conditions of service of the respondent number 5. If at all it was to be done, that had to be done with the permission of the tribunal.
Approval.
Permission or approval?
No, not permission, approval. Because the misconduct for which he is dismissed was not an issue that was pending in the reference.
So approval ought to have been taken. So if the approval was not taken, that means the order of removal from service would be non-est in the eye of law. Correct. Now, if that be so, what happens to the award passed by the learned tribunal? Because the reference was initiated at the instance of your client. Supposing the order of removal is non-est, you are the one. I'm just trying to understand the legal implications because this is a comparatively new area for me also.
My lord.
So the order which was challenged, so let's put it this way, moving away from the technical jargons. The order of removal which was challenged by your client was done at the instance of the respondent number 5.
Yes.
He goes to the court and says that declare that this is non-est or this is illegal. And the tribunal does it. It is not that they went to the tribunal.
Yes.
But the tribunal does it in a manner which is not envisaged by section 11A, according to them. What would be the impact of it? Will it mean that the entire matter is shut now for all times to come? Or
My
is
lord.
it just a procedural irregularity? Which can
My lord.
For example, please understand the question. Supposing an order is passed in violation of principles of natural justice. This is a procedural matter. The court will set aside the order but will not shut the issue on merit. The matter will be remanded for a fresh decision. Likewise, if your contention is that it was done without the approval of the tribunal, that does not put an end to or shut the issue on merit. This may at best be a procedural ground to set aside the award, but that doesn't mean he gets a clean sheet. It
My
cannot-
lord, my understanding of 33,
Hmm.
that along with the order of removal, you have to pay him 1 month wages and simultaneously file an application. You cannot file that
I
application.
understood that, Mr. Chakravarti. I am again asking you so that today, if we can't conclude, we'll definitely conclude in the next date. And I am fixing this matter on 25th of April, 25th.
My lord,
Can it be 28, my lord? 25th, 26th, my lord, I'm. out of town.
28, my lord,
Thursday.
Then it will go to end of May.
my lord,
It is
20,
not convenient for me.
But-
That also matters.
My lord, I'm sorry.
my lord,
convenience of the
25th,
judge.
26th, 27th, no problem, my lord.
Just choose a date after 22nd of May. Either 25th or 22nd of May. Before that is not.
2nd of May is fine.
22nd of May.
My-
22nd.
This is an ongoing matter. Why you are not available on 25th?
My lord, 25, 26, my lord, I'll be out of town. my lord. So,
In connection with another case.
some-
We'll fix it on 25th. You make alternative arrangements. On an ongoing matter in the High Court, you have another case cannot be a ground. Otherwise, it will go to a May, end of May, or even maybe June.
Possible lordship can accommodate on 28, Thursday, my lord.
28 is not a Thursday, first of all,
Sorry.
and it will not be
Or
possible.
27, my lord, 27.
27th will not be a problem. my lord.
So please, both of you give me a synopsis of your arguments
My lord.
with reference to the page numbers, etc. And Mr. Chakravarti, you have to also argue that even if the court accepts your contention, will it bring an end to the matter and merits?
Yes.
Where is
It
the
will-
authority to show that?
My lord, on the last occasion, I have given two judgment. It says that it is a mandatory requirement.
If it is not followed, the award will be set aside. Principles of natural justice is also a mandatory requirement. If an order is passed without following the principles of natural justice, the higher court will set aside the order and remand the matter for a fresh decision after complying with the principle.
My lord, what I am understood, my lord, this issue that the order of removal was passed during
So come
pendency of
prepared.
that reference, my lord, I will definitely address your lordship. But the thing is that
Not
order,
prepared, I am
it-
saying even if your arguments are accepted, even then it will at best be a case for remand and a fresh decision on merit. That cannot-
Merit
that
on-
cannot absolve your client.
my lord, merit on the charges.
Yes, because the award does not, either ways, Mr. Chakravarti, please understand. Either the award itself is non-est. Because the award was passed by the tribunal being oblivious of the fact that the order of removal was without the approval of the tribunal. That is one view. But if the tribunal interferes with the order of removal, then it has to give reasons for doing it. That is not one of the reasons that it was not, the compliance of section 33 is not the reason. That is not the reason.
That is not the reason.
There is no
but-
other reason.
There is no other reason.
Then-
Even, my lord, if the reason is bad,
Hmm.
for which the award was passed or the removal was interfered. But 33, issue of 33 is a question of law which your lordship can decide whether
Therefore,
on this ground.
Mr. Chakravarti, what I am asking you in very specific terms is, supposing they do it without the approval of the tribunal, the order will be bad, but will it put a full stop to the entire matter?
Yes,
Where is the judgment?
My lord. I'll, on that day, I will address your lordship on this point because 33 issue that constitutional bench.
On merit, the matter cannot be reopened. Is that
Yes,
the
it
judgment?
cannot be, it
The
cannot be.
management is completely shut out for all times to come.
Yes, my lord. I'll address your lordship on that day.
You have to meet that point.
My lord.
You have to meet that point.
He has answered the point that the issue of suspension cannot be a ground for invoking 33. What if I have understood his argument, he's saying that my issue of suspension was not answered or whatever it is, so 33 cannot come into play. But 33 language, 33 2B is very clear. If a reference is pending and I am connected with that reference, And for any misconduct not connected with that reference, if I am to be removed or dismissed, approval needs to be taken. So if that is not done, then end of the matter. I will address your lordship on this issue. on
End of the
27.
matter means the order goes.
Order of
Order
removal
merit.
goes.
Merit.
Order of removal goes.
Then what happens? The bank has no other option. Cannot do anything.
That is what Supreme Court said, that you cannot take benefit of your wrong. It is mandatory requirement. You are under an obligation to follow this. And if you choose not to follow this, then you cannot do anything.
But that judgment is. there.
Yes, my lord.
Which is that judgment?
My lord. 2002, volume 2, SCC 244. On the last occasion, I had given the list of books and Jaipur Jila Parishad.
2002.
Lordship may note these two judgments. I will bring it on the other day. That is on 27.
All right. What is the
Lo-
citation?
My lord, 2002, volume 2, SCC, page 244. And that is followed by 2003, volume 1, SCC 320. I'm just,
All right, but both of you please make a.
my lord, may, while noting this judgment, lordship may just note the relevant paragraphs 13, 14, and 15
Hmm.
of 2002 judgment.
You write it down.
My lord.
Had Mr. D. Kaushik, learned counsel for the writ petitioner, also had Mr. S. Chakravarti, learned counsel appearing for the respondent number 5, Mr. T.C. Chitial, and additional senior government advocate Assam has appeared for the respondent numbers 1 to 4. The arguments have remained inconclusive. Registered to list this matter again on 27/4/2023 as a fixed parted matter for further hearing. All right, now the problem is other matters have to be shifted. You take your dates, whatever. Please take your dates, but if you club all matters on the same day, the same result will happen on the next day as well. Therefore, it is better to space it out a little bit.
Oh, which office staff lordship?
Huh?
Do you have to mention here or?
You're giving the dates, which
Lordship.
dates you want. Tuesday, Thursday, Milai Vile, Didi Ball. Because today there is no time.